I'm a little confused, frankly, regarding this next case. To tell you the truth.
I hope to help resolve that.
All right. There are two cases. No, I guess just one. Donna Brown versus John Paul Reading and Christy Worrell. You're John Reading?
John Redding, but I'll take whatever.
Reading? All right. And you're Christy Worrell?
Yes, sir.
And you're Donna Brown?
Yes, Your Honor.
Will you all please raise your right hand? You all swear or affirm any testimony you're about to give will be true to the best of your knowledge and belief?
Yes.
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 All right. There are some things in here that you can't normally sue for in small claims court. As I said, a tort. You claim reimbursement, equitable indemnity, negligent misrepresentation against Christy Worrell and Mr. Reading in the alternative, and unjust enrichment. That one you may be able to sue for. $4,500. And then I've got a bunch of stuff that I frankly can't completely comprehend. The other matter, as I understand it, the parties were not married, but they share a child. So there was no divorce. Generally, in a divorce proceeding, you can't supersede the circuit court's jurisdiction by filing an action in small claims court, and people try to do it all the time. So there's so much here, I can't quite even discern it all. But Ms. Brown, why do you believe that they owe you $4,500?
Yes, Your Honor. If you give me a moment to give you the backstory, and I will try to present this the best that I can so that you get the best understanding to the situation.
All right.
So, Mr. Redding and I have two children together. We have court orders in place. I have sole legal and physical custody of the children. There was a court order established for both children that he is to provide insurance on the children and provide child support.
All right. Where are those court orders from?
They are from here within Centerville.
All right. St. Joe County.
St. Joe County, yes. And they are provided within the initial filing.
Yes.
Mr. Redding has not provided consistent insurance on the children. We have one child with very sick medical condition. He has kidney disease, which is bilateral hydronephrosis, and RASA1 genetic mutation. So insurance is very critical to him. I was at home taking care of children, and the children were both enrolled in state insurance. This suit that I'm raising, I had out-of-pocket expenses due to what I'm going to discuss when Christy Worrell added the insurance, and I'll explain to you why it would fall under a small claims case. So what had happened is I had requested friend of the court to have John uphold his obligation for his insurance, and he did start a policy back in February of 2024. However, he terminated that policy. That policy did not impact Medicaid on the children, did not impact my son's children's special health care. There was no impact. If I have primary insurance, it does not impact the children's Medicaid, secondary Medicaid. But what had happened is Ms. Worrell, without my permission, without my consent, used my children's information, social security numbers, did not reach out to me as legal guardian of the children or discuss this matter or how it would impact state insurance before putting them on a policy. And what she did is she put the children on a policy, but she used my address as her primary address. The state of Michigan, therefore, canceled Medicaid because she does not live at the address at 25951 Lantern Circle. So what had happened is, by her doing this, all medical bills then were rejected by the insurance company. And her insurance wouldn't cover either because of a dependency discrepancy. When she first enrolled the children, there was no marriage on file in the state of Texas during her initial hire and enrollment period. I had reached out to Atena, the insurance company, only on behalf of the children to try to see, once I got the Medicaid rejection letter, that there was going to be a lapse in coverage. And our son had important medical testing and procedures that were prior authorized and that he was going to be going for. So what had happened is this directly impacted where I had to change different plans of care around for our son because it would be astronomical medical bills. And I was able to move things where he only had 2 smaller University of Michigan medical bills, which I'm suing for, which I presented here, in the amounts of, I think, 88 for one and 200 and something for the other. I can get the direct amounts. And additionally, my daughter happened to have an emergency situation, so I was charged over $3,000 because no insurance would cover because of this choice made. I did not agree to that, and there was no prior friend of the court authorization, which was what they're saying. Later on, they said if a marriage was in place, but she still couldn't use my address, and I have right here to show you. This is Christy Worrell at my address in the state of Michigan. Of course, that causes dependency issues with state benefits. She does not live in Michigan, and these children are not her dependents. So what happened is I have direct financial losses due to this. Now, once her insurance...
All right, let's talk about those. How much are those?
Yes, so I have outlined within the summary. I believe it is on damages. If you go to attachment A, statement of claim, the damages I have at $4,500. This includes medical bills from University of Michigan, one for $88, one for $130, Sturgis Hospital $3,597.07. That subtotal equals $3,815.07.
Stop, slow down. I don't think that's added up in here. Oh, there it is, yes.
Yes. And also, he kept the United Healthcare insurance and not changed over to hers, that one would have done mileage reimbursement, so I have included that as well. I've also
just a moment. Mr. Stickley, I asked Shayna to call down there. I don't think I'm gonna get to our friend, Mr. O'Brien.
I was just checking in because I was going to chat with you about something else, Your Honor. I didn't know how deep you still were. I didn't even know.
I'm up to here. So I can, tomorrow is Veterans Day, and we won't be here. I'll be on WBET at 7 a.m. if you want to listen to my radio presentation, but we'll work on it. The magistrate set his bond at $50,000 in his other case. It is not he's already pled guilty. He's just pending sentence.
Yep.
So we'll address it on Wednesday.
Okay. Enjoy your day tomorrow. Have a fun time on the radio, and I'll see you Wednesday.
All right. Thank you. Thanks for checking in. All right. I'm sorry. We had a criminal matter that we didn't get to. But go ahead.
Okay. In addition to that, the filing fees and process server fees, which I did submit through your clerk, and she did print me up a copy.
They're separate.
If those could be included as well.
Well, those can be in excess of any other claim. All right.
Additionally, there is a lot of problems between the parties and I, and her counterclaim for day off work, she would have had to take it already because we did have PPO hearings this morning.
Well, you normally can't sue for that sort of thing.
That was a counterclaim that she placed on me for time off work. So I'm just saying that she would have been in court today no matter what, had this case not been.
All right. There's a bunch of other stuff in here which isn't relevant. Pictures of Hummers and a bunch of stuff.
So what that was in regards to, Your Honor, is...
I don't even want to know. We're just going to deal with these. So it's your contention that without your consent, and I'm not sure they need it. They had his consent. And he's a parent, but they changed insurance. And because of that insurance, it eliminated your additional emergency health care benefits you had in the state of Michigan, resulting in costs that would have been covered, but were not.
Yes, and he is ordered within the order to pay out-of-pocket expenses. John Redding is. Mm-hmm. And as far as...
Now, that's up to them. You can't ask me to enforce anything
from friend of the court.
Friend of the court.
However, Christy Worrell should not have insured the children. I do have sole legal custody of the children, and any medical decisions would be up to me, not father at this point in time. And as
All right,
far
what's
as
your authority for that?
I provided it on there. That is in our parenting custody order. One was in 2015.
Well,
for
let's
Kaylee.
take a look at that.
Yes.
Uh,
In 2021, I
Let me
believe.
see if I could find it. There's so much stuff in here.
If not, I can pull it up on my computer and show you, Your Honor. I may have only included the
Here it
support.
is. Set funky. All right, uniform order. What clause here?
I can show you this. It is ordered that plaintiff shall have physical and legal custody and care of the minor children of the parties. If you would like to see, I can bring it up.
I think I have it here, but I'm front of the court orders are what paragraph?
So I'm not sure if this is in the full filing or if this is its own independent order. If you'd like to show this stuff.
I can take you to something else.
Okay.
The defendant shall maintain health care coverage through the insurer that includes payment for hospital, dental, optical, and other health care expenses. And that coverage is available at a reasonable cost, including coverage available at a benefit of employment or under an individual policy, up to a maximum of $375 for the defendant. As for Kaylee reading and John reading, I'm not sure which paragraph you're speaking about, which says you have.
I have it here. It may not be included, but this you can look within your system. This is file number 15839. And then they combine the dockets.
All right, well, what paragraph are you looking at in that document?
The first paragraph, it says Donna Brown, plaintiff.
Yes.
John Redding, order for custody, parenting time, and other relief. All parties have agreed to the court otherwise being fully advised of the premises. It is ordered that plaintiff shall have the physical and legal custody and care of the minor child of parties, Kaylee Redding. And there's a second order for John Redding that is the similar verbiage where I have the physical and legal custody at this time of the children.
All right, now let's talk about this $3,800 bill for Kaylee. What is that about?
So she had a high temperature, an emergency matter, and she had to be taken in. My mom had taken her in. I was trying to avoid taking children in during the time, knowing that there was this insurance crisis that was caused. The bill came to $3,000. I told you how much it came to, over $3,000. And I do have a letter from Sturgis Hospital. It says that please be aware the insurance company, you advise this bill has delayed the processing of your claim because of a coordination of benefits issue. When I called Aetna on behalf of my children, it was due to a dependency issue. There was an ineligibility issue with her insuring the children. That that caused the problem, and it caused the Medicaid to drop.
All right, so have you paid that bill?
The bill is still outstanding, $700. I'm working with Sturgis Hospital to get it resolved. I'm still out. I still owe U of M as well, all of the other bills.
Well, how much?
This is what I'm out, this amount right here, and you can hand it to, this is the amount that I'm out for those two, and here's for those two. That's my total that I'm out.
$38,130.
And if you could also give him this shows that
But-
she used my address in Michigan.
You haven't actually paid that $3,597, is that correct?
I have a payment plan that I'm working with Sturgis Hospital to try to situate the situation. They're trying to rebuild things, trying to do everything that they can to try to work with me. Currently, that's the amount that is going to be showing on my credit if not fully paid.
All right. So she's laid out why she believes you owe this. It's not equitable indemnity or negligent misrepresentation. It's that you changed your insurance. Now, I'm sure it was done with good intention to put the children on your insurance, but under the way it worked out, she contends it made her ineligible for the other coverage that she had, and then your insurance didn't cover it.
Your Honor, when I brought it to their attention.
Just a minute.
Okay.
May I say something?
Yes.
So prior to us insuring the kids on my insurance, we called the friend of the court and had them review both of the policies that John was responsible for. And they gave us permission to put the kids on my insurance. And in Texas, they actually recognized domestic partnership, which we did file as of 1/8 of last year. And so under my insurance, actually, John is a dependent. It's actually domestic partnership dependent is how it's phrased. And then his kids are listed as domestic partner dependent. So he's my domestic partner. And then I had to choose under the option for his children, domestic partner dependent. So that's how it's phrased in the healthcare world. And when she, so in.
All right, let me stop you for a
It's
minute.
an option.
Let me stop you for a minute. So I'm not familiar with Texas, but in Michigan, if you were married, you could cover his children under your insurance policy.
So it's the same thing, Judge.
All right, so in Texas, it's not called a marriage, it's called a dependent partnership.
So we filed it.
Informal marriage.
Yeah.
It's stamped county seal.
So
All right, what's the date of the marriage?
it's as of 1/8 of 2025.
That is incorrect. I do have, they filed it in,
I didn't ask you anything. I'll give you a chance to speak. This is their turn.
We did file it on March 27th, but on the paragraph, it actually says on or about 1/8/2025, we agreed to be married. And so in their system, it actually is dated as 1/8/2025. And
All right.
so it's the same thing. So it's seen as a marriage whenever you're putting them on there. And because of the turmoil and the disputes between John and Donna, we had been advised by a friend of the court to send her kids' cards directly to the home. If I would have used her address as my permanent address, I could not work for that company. I could not be insured in the state of Texas. My kids were also insured under that policy. I was insured under that policy. Our cards came to my home. Their cards went to their home. And Donna called my work place of employment so many times that they called me and told me that it was concerning and I probably needed to consult an attorney for how concerning it was with what she was saying. And so later after that, I actually had my company reach out to the Medicaid in Michigan to make sure that they were still okay. And they said that there was no conflict of interest between my insurance and the insurance between the kids, that there was something probably that was done on Michigan side that was not correct, but from their research and what they had entered, it was non-conflicting to the kids.
And in fact, if you look on Exhibit 8 that she
Just
submitted.
just a moment. What's the matter?
Oh, I was just granted
I took it.
Oh, you did? Okay. Thank you. Sorry.
All right. Who did you talk to at the friend of the court's office?
It is, we spoke with both Amy Wright as well as on the 5th, Liz.
Amy Rice?
Right.
Right.
WRHT.
And then Liz?
Yes, Your Honor.
Do you have a caseworker from friend of the court?
I believe it's either Amanda or Liz, Your Honor. I've got email correspondence from myself and the friend of the court when we sent them insurance cards. That.
All right. So before you transferred the children to your, now what insurance had you had, Mr. Redding?
So prior, which one was it?
I think it was UHC maybe.
I lost my job. And so it's a court order that I carry insurance. So my wife was nice enough to help me insure the kids to make sure, obviously my son has a lot of health issues. And I feel like that a lot of the reason why maybe something might not have been covered is because she was blowing up the insurance company's phone as well as my wife's employer regarding why it shouldn't be covered, as she's outlined in her exhibit 11, when it's just messages of her not wanting to allow the children to be insured.
By myself. She did not want me to insure them, even though Texas recognizes us as being married and I can insure them under my policy. They actually started insurance under my current policy as of 10/1, and I haven't heard anything of it affecting his insurance at all. So I'm not sure what the discrepancy was on her end. I don't know if she missed turning something in on her end, and that's why they weren't covered by Medicaid. But I personally had Aetna call my benefit specialist under the Dependent Health Services, call the state of Michigan Medicaid to make sure that there was no conflict of interest between their policies and mine.
And on her exhibit 11, it even says that there's a form that she can return and complete on her exhibit 11.
I object to false evidence.
Here,
Well,
if he was stated here,
They're making a lot of false claims.
Slow down. These exhibits, I'm trying to find exhibit 11. There's so much extraneous stuff in here. It's hard to, I don't know what is exhibit 11. All right. So your contention is you lost your job, so you didn't have any insurance. So you got married in Texas, and your wife's company is willing to insure her new spouse's children. So she put your children on her insurance to comply with the Michigan court order. Is that correct?
Yes, Your Honor.
All right. And you called the friend of the court first and said, hey, we're going to do this.
Yes, Your Honor.
That is incorrect.
Well, we'll find out. We may have to call them. And so that was done. And I wasn't clear exactly what you talked about when your partnership was. When was the date that children placed on insurance?
As of May 1st of 2025.
I have a letter that says from April 14th, the children, that's when the cards were mailed to me. So that is incorrect, Your Honor.
Say that again.
Only when-
April 14th, I received the letter, so May 1st is incorrect, Your Honor. The children were insured already in the month of April. The informal marriage that they submitted was 3/27/2025. There was no record with the state of Texas during the time that she enrolled the children, which is why the beneficiary situation started. I had called Aetna, not her employer, multiple times. That is incorrect and lies. There is also a false police report that Ms. Worrell has submitted on me in regards to that. I only called in regards to my children's insurance, where Aetna themselves are the ones that told me prior to any medical treatment. That's how I knew it wasn't going to be covered, because Aetna said, no, this is going to cause major dependency issues, because the way that this employer works, that
That's not correct,
your
Your
children
Honor.
can't be dependents. Excuse me, it's my time. What had happened was...
Stop.
It might April 1st. I could have been misconfused on the dates, but
They were insured.
All right, so either in April or May, the children were on your insurance.
yes, it was either April 1st or May 1st. I mean, they were.
Well, the point is, the date of service here was May 27. Is that correct? For your daughter?
I believe the date of service, yeah, there was about a 2-month period that the children were enrolled. The insurance started April. I believe it ended in June. I got a COBRA statement that insurance had ended. That was sent June 11th. So insurance was terminated during the month of June. I did notify Mr. Redding and Ms. Worrell that, hey, this is going to impact. I also went to DHS office.
Stop. I ask short questions and you give me a long paragraph.
I apologize.
So the date of service for your daughter was May 27th. Is that correct?
That is what it shows on the bill. I believe
All right.
that's the date.
The dates of service for your son were April 29th and May 16th. Now, they billed United Healthcare Community Plan Insurance. Whose insurance was that?
That would be the state of Michigan that rejected. They were on a United Healthcare Community Plan. And it became active once Christie's policy ended. It reactivated.
Well, it says not billable service. I'm not sure what that means.
It's because she had started a primary insurance with a dependency issue. I'm also the one who reached out to friend of the court, and when I got this on April 14th, and friend of the court had no knowledge, they had to actually look into it, and there should be some emails looking into it. They later determined if a full marriage did take place, they don't care who insures the kids on that end, but they did not call and get this approved ahead of time. I'm sorry that they did lie, though.
Well, we might have to hear from friend of the court. Right now, I'm sorry, go ahead.
Their exact wording was, I've entered the insurance information in our system that children have coverage through a third party, Christy Worrell. That's directly from Amy Wright from the court.
so we did call prior.
What was the date of that?
That email was on that's the most current one. I apologize. Let's see. This one is on October 9th for again, and then because we changed the insurance again. The first one was when I sent the email cards to Liz was on May 5th.
That was after the 14th.
That was much after.
Prior to us changing over, we did call because I was with John, and we did call the friend of the court because we were not going to change the kids over to my insurance policy if they did not give us approval. So because I also have kids with other gentlemen, and so I know how the court system works, Judge, and so I was not going to allow John to let me put them on the policy if the friend of the court was not, if it wasn't under his his order. Because I know what trouble it brings, and so I wouldn't put myself in that situation in doing so.
But we're literally getting sued because we insured my kids, which is court ordered.
And honestly, I don't know why they paid so much money because from, if I can remember correctly, the policy was either $150 for the ER visit, and that was the deductible, and or it was $250. I can't remember which one. If it was admitting, it would have been $500. And so the policy I actually obtained was the highest PPO policy that I could actually obtain through my insurance company, so they could have the lowest out-of-pocket deductibles. And because I knew that Johnny was sick. And so, but me being a mom, I have 2 children, we have court orders as well. I would not have allowed John to let me put them on my policy without permission from front of the court.
And I feel that if she was as difficult with us in regards to just sending her insurance cards as she was with a hospital, I would, or with any of the insurance companies, I would assume.
Objection.
Okay.
I'm not sure. I didn't even hear what he said. But what he did say is, I'm being sued because I put my kids on my insurance as I was ordered to do by the court. Now, that is well and good, but her contention is because of that, I now have a $3,597 bill. But it doesn't yet sound like it's completely rectified. There may be a
Actually send me the
benefits.
paperwork, Judge. I will fill it out and I can contact the hospital and submit that because I also handle claims under my current position. So if she would like help with that, you could actually email that to us. I'll fill out the form myself and make sure that was covered under that insurance policy. And even if it was $250, John actually has something under the friend of the court to where she submits that into the friend of the court for him to pay through his child support. So, I mean, that's honestly, I would be willing to help fill out all those forms to make sure that all of that was covered if she was unwilling to use my insurance card because she is prideful.
Your Honor, they're twisting this around from really what's been going on in this
All right, well,
situation.
let me stop for just a minute. What insurance is on the kids right now?
I'm currently covering them under Blue Cross Blue Shield as a primary, which is why her primary is not impacting the children right now because they are under me and they have Medicaid as a secondary. Medicaid works with any primary as long as there's no dependency issue. They were notified that there was a dependency issue prior to the children receiving any bills, and Christy Worrell and John could have, at that point in time, dropped the insurance. There wouldn't have been any issues. There wouldn't have been any bills. They refused
The
to.
problem is he's ordered by the court to have insurance on the children.
And there was no problem with him covering the children.
Okay.
And he also had lapses in insurance prior. What had happened is, once they used the children's information, and I had found out that they had used the information and it wasn't going to insure the children and it was going to mess up our son's health care. And I had a whole bunch of prior authorizations and things for him to be sedated for like his MRIs and all these things set up. And it's still now delayed to this day. And it's a big thing for our son to have care delayed. So they can paint a picture that they're trying to help. But what it was is there's a huge other problems going on with financial control and abuse. And this would put me in a worse situation. There's
All right,
a whole
well,
other
let
case
me
going
back
on.
up. He's ordered by the friend of the court to provide insurance for the children. That
Yes.
order's in effect.
Yes,
So he provides coverage for the children through his spouse's health care.
they filed this, I believe, with the intention of insurance fraud. They state this back to 1/8 of 2025, but they were at my house on the property with police called on 1/25 of 25, and they did not report themselves as married to that officer. They presented themselves as boyfriend and girlfriend. What they did is they filed an informal marriage after I reached out to the state of Texas and said someone had used my children's information without legal grounds to use the information to start this policy that's now impacting my children's health care.
So I don't believe that. I don't think he went out of his way to insure these kids just to screw with you. I think he was trying to comply with the court's order. Now, so you're rejecting that coverage for the children currently?
They had ended it. They basically screwed it all up. And then she cut the policy. Why did you cut the policy? You can ask her. I don't know.
So you called my job so many times, they fired me. So thank you.
I never called the employer. I called the beneficiary
All
line
right,
through Aetna.
so,
They fired
so you
me
lost,
because how many
you
times-
lost the job that had that insurance?
Yes,
Is that
sir.
true?
She called so many no, that's not my current position. I'm with a different company, but she called my job so many times, they let me go the following week. That's why they lost coverage at the end of June. So thank you for that.
If I never did had anything to do with
I know
her
it wasn't
or-
your intent. However, it happened.
All right.
They also just recently
All
sold.
right, stop just for a minute.
Yes.
All right, so you put them on this coverage either in April or May. Then because she called your place of employment so much, they fired you. So
Yes,
you
sir.
lost your job and lost that insurance.
Yes, sir.
All right. So are the kids on any insurance between the two of you now?
Yes. So I waited because I waited till I found a good company because healthcare is kind of hostile. And so I found a company that I'm currently working for. And that's why I get it confused. Some start within 30 days, some start within 60 days, some start within 90 days. So it's hard to keep up with. But with my current employer, it started as of 10/1 of 2025. And it's also an Aetna policy. And the max out of pocket for both policies, Judge, was no more than $4,000. So one visit to the medical, you could have gone to the ER. That bill alone, if she did not file under insurance and paid the $250 deductible and sent the bill to John, it would have actually covered everything moving forward for Johnny at zero deductibility. Same thing with this policy, Judge. I got the highest PPO plan possible because I know he is ill, and I have children myself, and my daughter is also ill, also has a blood disorder. So it's very important that they have the policies correct. And so I made sure that they had the least out-of-pocket expense and the lowest deductible to make it the most easy. So Donna can just submit any receipt that she has into the front of the court, which it seems she's refusing to do so.
Not to mention that the deductible, from my understanding, gets eaten up by the state insurance that
Well,
she
it's not
has.
just the deductible, it's the max out of pocket. I got the lowest max out of pocket. The deductible for my current policy, and now I think for family it was 4,000, and for out of pocket it was like maybe 4 or 6 for the last one. This one is only 6,000 and $1,000 deductible. So literally one visit to the doctor's office and it'll cover everything.
All right, so right now, these children are covered under your employer's Aetna policy from Texas.
Your Honor, I pay $1,600 a month for my children's insurance.
I didn't ask you anything. I'll come back to you in a minute. So are they on your policy in Texas
Yes, sir.
as of
The same-
October 1?
Yes, sir. The same way I did it last time, I did it this time. They offer a domestic partner and then domestic partner dependent, and I can actually send that into the court so you can review it.
All right. Ms. Brown, your indication is that you now have a Blue Cross Blue Shield policy?
I've been paying insurance because I had to do what I had to do to make sure that our son could get his medical care needs met.
And when
I also would like-
did you start that?
In June. And I also would like to show Miss Worrell just sold her home. And she sold her home and signed a single affidavit at the same county in Texas. And here is her official deed that she sold her home. This was public records. I only obtained public records. I also never contacted her employer like she's saying multiple times, and she has just recently falsified a police report.
Stop.
But I'd like you to see.
Stop. That's not relevant. I believe she got fired because you called her boss in her
I'm
employment.
not called the employer.
Well, I believe she lost her job because of your earnest efforts
My
regarding this
understanding is she had
insurance.
misdemeanors unreported.
All right. Now, so you bought your own policy here in Michigan in June. So are the kids double insured?
I'm not aware that they even have a policy. I just know that right now, when I've gone to the doctor, no other policies have showed up other than the Blue Cross Blue Shield, and the Medicaid is a secondary.
She should have received that from the front of the court. It said, again, we sent it to the front of the court on October 9th, where it says that the showing the children have coverage to a third party, Christy Worrell.
Effective 10/1/25, medical and RX coverage, vision and dental coverage as well. I got, like I said, Judge, I actually.
Because no matter what Miss Brown does, you're still ordered by the friend of the court to provide health insurance. Is that correct?
I am.
I offered with friend of the court to sign off on that coverage just so that they wouldn't mess up, so that my son can't get his health care again and me get stuck with $3,000-$4,000 in bills. If they cover an insurance, it has to actually cover the children and not kick him out of all of his other insurance. The problem is I'm out financial losses from this decision, and they chose to not remedy it. All they had to do was
I
stop
can get the
insurance.
form to fill out for you, because I know that you didn't turn in the insurance card and now you brought us here and it's frivolous. But if you would actually send that to the friend of the court to send to us, I'll fill it out for you. I'll call the hospital and I'll get it taken care of for you. And I'll submit all the receipts to the friend of the court.
Your Honor, there's been some extreme manipulation into the children's health care because John is wanting the kids to go to Texas, and there's flight restriction list. They have both called University of Michigan MOTS, and they have prevented health care for the children. They have made it where my phone number has been changed. And what has happened is it's extending out my son to get his MRIs and his images, which will make him ineligible to go to Texas for the visitations. And that's what this is probably over. There is more to this story. They might sit there and tell you that, they're nice people trying to insure the children, but you weren't in the PPO hearing this morning. I am out thousands of dollars. Him and I still.
Well, you're not out yet. Sturgis Hospital's out at this point. If some insurance company will pay it, it could be reimbursed to the hospital.
I just want to be rectified for the amount that I'm out of pocket had this not happened.
Yes, and let's assume everything that you say is correct. Then what is it? Is it an unfortunate accident? They have a court order to provide insurance.
John does. Christy does not.
Yes. He loses his job. His wife, or whatever they call it in Texas, domestic partner, agrees, which she didn't have to put the children on her policy. They say they called the friend of the court and told them that, and they did it. Then in the case of the right hand not knowing what the left hand was doing, it somehow made your children ineligible. And I'm still not completely clear about that. But
Your Honor, he quit that job.
Stop.
Yes.
Stop. I'll give you a chance to speak. You don't have a chance to coordinate my thoughts. So what is that? He follows a court order and gets insurance. He checks in with a friend of the court, and they say, okay. Unintended consequence is that there's an unpaid bill. They maintain if it was submitted, they would submit it and get it paid. Your theory is that they somehow did this with nefarious intent. So what's your response to that?
Your Honor, I've been subject to extreme financial control. Mr. Redding and I, we own a home together. I had, during this same exact window, I had a forbearance for the home that was filed, and he called and canceled that so that I would almost lose the house into foreclosure. The house was run through court. He ended up requesting dismissal based on rights of survivorship so that I couldn't sell the house. So I've been completely financially trapped in this situation. All of those other things were added on, all of his sales. That's his job that he's not reporting to the IRS or to the friend of the court, making hundreds of thousands of dollars a year. Him and Miss Worrell have just recently bought a new home. On the old home, she filed single and not homestead when in the same county in Texas. So that would hide the asset. He owes over almost $10,000 in back child support. Yes, he quit the job, but he didn't quit the job to help these children and put them on her insurance, like he's saying. There's a whole lot of backstory to this, Your Honor, and I'm being honest. A whole lot of backstory of domestic violence and everything else that's going on in Judge Patterson's courtroom right now, and with the home and with finances. And this was just one other tool. This was just one other tool to set me back. They were made aware. I told them, this is going to charge me out of pocket. Please remove the insurance so that the children can continue the care under the Medicaid. All they had to do was remove it. We could have worked with friend of the court or changed an order. They could have put in a request to not have to insure the children. That didn't happen. They knew that the children would not be covered due to this dependency issue. They continued to keep the insurance. It in turn caused me out thousands of dollars. It increased more financial strain to me. There is a lot more. Then a false police report was made, and even to you in this court saying I harassed an employer. She did not. She lost her job over what I'm assuming is at a healthcare facility and didn't report her misdemeanor. She is also being charged right now for child endangerment or neglect or hurting her.
And that is irrelevant.
Stop. Is there any more bad stuff you want to say about them? This isn't about that. This is about all the background. And you're angry and you're resentful and you've got a list of grievances longer than my arm.
Yes.
But they followed the friend of the court order to provide insurance. You didn't have the authority to unilaterally tell them to take the insurance off of there. This is also more a friend of the court matter than it is a small claims matter. And people often try to jumpstart a divorce or custody and visitation order by taking it to small claims court. So that's the first fundamental problem. It's a friend of the court issue rather than ours. And secondly, I find they were in compliance with the court order. So I find for the defendants, the damages are zero. If you want further argument in the front of the court.
Your Honor, I can't submit to front of the court beyond the time that it took for the insurance to try to run these bills. That's why I'm asking you to please help me make this right, that they have.
Well, you can give the bill to them and they will do it. But I find that they were complying with the friend of the court order and they provided the insurance. Take her out, she get a copy of that. We'll send a copy to you. All right.
This case explodes with confusion from the very first second. A mother claims she's drowning in thousands of dollars of medical bills after the father followed a court order. Insurance switches, Medicaid cancellations, alleged false reports, job loss, and accusations of financial control all colliding inside a small claims courtroom. But here's the real question: did complying with a court order accidentally create financial chaos, or was something deeper going on? Now we get to the heart of her claim. She has sole legal and physical custody. Under most custody orders, that typically means major medical decisions fall to her. However, and this is critical, the father is still under a separate court order to provide health insurance. Those two orders can coexist. The legal tension here isn't about who loves the children more. It's about whether adding insurance without her consent was unlawful, or simply an administrative misfire between primary insurance and Medicaid coordination of benefits. That distinction changes everything. This is the turning point. The judge lays out a hypothetical: assume everything the plaintiff says is true. Even then, if the father followed a valid friend of the court order to provide insurance, checked with the office beforehand, and an unintended coordination issue occurred, that becomes an administrative problem, not tort liability. Small claims court cannot enforce or reinterpret custody orders. That authority rests with the friend of the court. This is why jurisdiction matters. The wrong courtroom can sink an otherwise emotional argument. In the end, the judge rules for the defendants, 0 damages. His reasoning? They complied with a standing court order to provide health insurance. Any billing confusion, Medicaid lapse, or reimbursement dispute belongs back in friend of the court, not small claims. This case highlights something powerful: emotional harm and legal liability are not the same thing. The courtroom demands proof of wrongful action, not just painful consequences. So, what do you think? Was this truly an innocent insurance mishap, or a deeper custody power struggle disguised as paperwork? If you found this case as shocking as we did, hit like, comment your thoughts, and subscribe for more intense courtroom breakdowns.